Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Amin Sofia binti Muhammad Syarizan and I previously studied at Sekolah Menengah Imtiaz Yayasan Terengganu Dungun.
Assalamualaikum. Allow me to introduce myself. My name is Nur Ilya Fazana binti Syaidan and currently studying law. Previously, I attended to SMK Kampung Pasir Putih, Ipoh Perak.
Assalamualaikum. My name is Tunku Intan Syafinas binti Tunku Muhammad Kamaluddin. I was previously a student at Sekolah Menengah Agama Kampung Laut.
Assalamualaikum and hi, my name is Nurul Isa binti Azhar. I completed my secondary education at Mahat Al-Mashhur Al-Islami in Penang.
Assalamualaikum warahmatullahi wabarakatuh. My name is Rabiatul Adewa binti Mahazanan and I previously studied at Sekolah Menengah Kebangsaan Agama Datuk Haji Abbas.
Assalamualaikum and hi everyone. My name is Siti Nabila binti Mat Rahim. My previous school is Sekolah Menengah Kebangsaan Tan Soo Penampang Sabah.
What inspired me to join law school is quite personal. My uncle is a judge and many of my relatives are involved in the legal field. So that environment naturally sparked my interest in law.
The main reason I pursue law is because it can master language and also logic. By legal training, it can train our brain to sharpen the way we think.
The reason I chose to study law is because I want to learn about the laws of Malaysia on how they apply and maintain fairness in society.
The reason why I chose to study law is because I've always been interested in justice, especially when it comes to protecting the rights of others. I believe that understanding the law can help me speak up for those who can't speak for themselves, and that's something I truly care about.
My passion for justice and the interest in legal matters have motivated me to pursue law.
I chose to enter law school because I have always wanted to understand how the law works in real life, especially how it affects society and individuals.
After completing my diploma, I plan to further my studies in LLB program and my goal is to work as an ambassador in an embassy. In terms of career, I am particularly interested in becoming an ambassador or a criminal lawyer as both involves critical thinking and public service.
So my plan after diploma is to work under the government legal department for several months before continuing into degree law. I wish to become a judge, a research officer, where it helps the judges to ready the memos and analyze the precedent and more.
After finishing my diploma, I plan to continue my studies to the degree level at UNIZA, and in the future, I hope to work in an office-based legal job that doesn't require me to appear in court. For example, I am interested in roles that involve legal paperwork, contract review, or giving legal advice from behind the scenes. When it comes to career interests, I want to be in a legal field that offers good financial opportunities. So I am thinking about working as a corporate legal executive or legal compliance officer in a private company or business.
After finishing this diploma, I plan to further my studies in the LLB program, and my goal is to become a qualified lawyer and work in the criminal justice field. I am especially interested in criminal law because it deals directly with real-life issues like crime and justice. I want to be part of a system that ensures people are treated fairly and given proper legal representation regardless of their background.
After completing my diploma, I want to continue with the LLB program to deepen my legal knowledge and become a qualified lawyer. My career ambition is to become a civil lawyer as I am passionate in helping individuals resolve disputes fairly.
After finishing my diploma, I plan to further my studies in LLB because I want to deepen my knowledge and become more confident in handling real legal issues. My goal is to become a civil lawyer one day because I'm passionate about helping people solve problems involving contract, property, and other everyday matters.
Throughout this semester, I've gained so many valuable skills, both soft skills like teamwork and communication, and hard skills such as legal research, drafting documents, and using legal database effectively.
The skill that I gained so far is communication. I ensure that I want to get the message that I deliver to them.
Throughout this semester, I've gained both soft and hard skills. For soft skills, I've improved in teamwork, especially while doing group projects and presentations. I've also developed better communication skills when discussing legal topics with classmates. For hard skills, I've learned how to do legal research using online databases, how to understand legal cases, and even how to draft simple contracts and legal documents, which are very useful for my future studies and career.
Throughout this semester, I've gained many valuable skills. In terms of soft skills, I've improved my teamwork and communication, especially during group discussions. And for hard skills, I've learned how to do legal research using online databases, draft basic legal documents, and apply statutes and case law to real scenarios.
Throughout this semester, I have enhanced my social skills, especially in communication and teamwork, while also developing hard skills such as using a legal database and drafting a contract effectively.
This semester, I have improved my teamwork and communication skills, especially through group projects.
First, I'll be presenting a legal analysis of Zarina's transaction with Smart Stocks and Nivian Berhad. Zarina signed up for a business service via a chatbot. She paid RM 4,500 based on claims like cut waste by 19% using AI. However, the product was just a manual Excel tool, not an AI system. She also couldn't read the contract terms before clicking buy now. Let's look at the 3 key legal issues. First, consent. Was Zarina's agreement valid if she couldn't read the contract terms? Legally, consent must be informed. If the terms are hidden or inaccessible, consent may be invalid. Second, misrepresentation. SmartStock claimed the tool was AI-powered, but delivering a manual Excel tool may amount to false or misleading representation, which can be challenged under consumer protection laws. Third, exclusion clause. Even if the company included hidden terms to avoid liability, exclusion clauses may not be valid if they are not clearly communicated or if misrepresentation occurred.
For the contracts become valid, it must fulfill a few requirements. One of them is called consent under Section 13 of the Contract Act 1915. The consent also must freely given as stated under the Section 10 and 14 of the same Act. The case of Lai Fei Wong Yu and also the case of Shin Nambi and also Tai Kim Chu, where both cases explain that if there is a element of the fraud, misrepresentation, coercion, the consent will not become a valid consent. Many forms of digital agreements, including browse wrap and also click wrap. The click wrap require the user to click the button agree before proceeding, but only if the terms are clearly presented beforehand. Okay. In the scenario described, Zarina clicked the button buy now without access to a contract term, show that there's a lack of informed and also voluntary consent. So high pressure tactics that prevent reviewing terms can invalidate consent and render the contract voidable, meaning that the buyer may choose to cancel it.
Now, I will explain the legal impact of digital practices such as clear agreement in the case of Zarina and SmartStock SDM BHD. In today's digital age, the contracts are formed through online platform using clear agreements where the users are required to click I agree without reading or fully understanding the terms. This undermines the doctrine of free and informed consent, which is essential for a valid contract under contract law. In Zarina cases, the chatbot aggressive and fast-paced approach did not give her an opportunity to review the contract. As a result, the consent obtained was neither free nor informed. According to the contract principles, such agreement may be challenged in court due to the lack of proper notice and acceptance. While digital contracts offer FSC, they must meet the legal standards of consent. Failure to do so in Zarina situations where the renters of the agreement is questionable and potentially voidable.
I will be explaining the issue of misrepresentation in Zarina's contract with SmartStock STMBHD. Misrepresentation is governed under Section 18 and 19 of the Contract Act 1950. It refers to a false or misleading statement made by one party that causes the other party to enter into a contract. According to legal academic Nurhan Hidayati Abdulmanap, even if the statement was made innocently, it can still affect free consent, which is a basic requirement for valid contract. It is also noted that the Act doesn't clearly separate the types of misrepresentation, but the legal effect remains the same. The contract becomes voidable. In this case, Zarina relied on promotional claims from SmartStock, such as cut waste by 90% using AI forecasting. However, the actual product was just a basic Excel tool with no AI features. This is very similar to the case of AWC Berhad with Point Euro Malaysia STMBHD, where the court found that misleading marketing statements, even if not written in the contract, still amounted to misrepresentation. On the other hand, we looked at the case of Miyako Manufacturing with Yu Kang Lai, where the court rejected the misrepresentation claim because the party had a fair chance to understand the contract. But in Zarina's situation, the agreement was made through a fast chatbot system, and she had no real opportunity to check the truth of the claims. This gives her a stronger legal basis to say that her consent was not given freely. Therefore, based on the law and supporting cases, Zarina may cancel the contract under Section 19. This shows how misrepresentation can seriously affect the validity of digital contracts. That's all from me. Thank you.
Now, I will explain why the exclusion clause in this case is likely not valid. First, the clause was not shown clearly. It was hidden during a flash sale, and under the law, important terms must be shown before the deal is made, not after. Second, the wording of the clause is too vague. It's unclear and confusing, which goes against the legal principle that terms must be specific and easy to understand. Third, the clause doesn't clearly mention negligence. The law says that if you want to exclude liability for negligence, you must say so clearly, and SmartStock didn't. Fourth, under the law, you cannot exclude liability for fraud. Even if there is a clause, it won't protect a party if fraud is involved. And lastly, the sales method was unfair. The customer was pressured to agree quickly and didn't get a proper chance to read the terms, and that makes the clause even more questionable. So, based on all of this, the exclusion clause is likely invalid.
I will explain the legal remedies available in the case involving SmartStock Sdn Bhd. The first remedy is rescission, which means to cancel the contract and return both parties to their original position, like the contract never happened. In this case, SmartStock Sdn Bhd advertised that their service includes AI forecasting, but in reality, it was only a basic Excel tool. This is fraud and misrepresentation. They also claim that AI would be added soon, which caused confusion. Zarina paid 4,500 ringgit for something that didn't match the advertisement. Under Section 19, Subsection 2 of the Contract Act 1950, if the consent was caused by fraud, the person can choose to cancel the contract. If the company refuses, Zarina can bring the matter to the court, but Zarina must have evidence like screenshots, ads, and transactions history to support her claim. The second remedy is restitution. This means asking the company to refund the money because they didn't get what was promised. According to Section 65 of Contract Act 1950, when a contract is cancelled, the party must return the benefit received. So, in this case, the company should return Zarina's money. To conclude, both rescission and restitution can be applied, but Zarina must act quickly and prepare strong evidence.
To conclude our case study on Zarina and SmartStock STMBHD, Zarina has a strong legal ground to cancel the contract. Firstly, her consent was not valid. The clear agreement doing a fast chatbot did not give her a real chance to read the terms. Under Section 10, 11, and 14 of Contract Act 1950, but valid consent must be given freely and informed. Secondly, there was a clear misrepresentation where the SmartStock advertised an AI tool but delivered only a manual Excel sheet. This was claimed under Section 18 and 19 affected her decision, as seen in the case Nur Hayadayati v. Abdul Manak case. Thirdly, the exclusion clause is enforceable. It was hidden, vague, and cannot exclude liability for fraud. Under the contract profitable, unclear terms go against the party who drafted them. Therefore, for remedies, Zarina is entitled to discussions and restitution under Section 19, Subsection 2 and Section 65 to cancel the contract and recover 4,500 ringgit that she paid. In short, the way the lack of consent, false claims and under fetters, the contract is voidable. Zarina should keep all proof to proceed legally.